Welcome back to another deep dive, listeners. Today we're, well, not tackling the most upbeat subject, but something really important to wrap your head around. What happens when someone dies, and how their estate, their stuff, is actually managed. You guys have been digging into the whole world of personal representatives, executors, and administrators. We're here to, well, kind of untangle it all for you.
Yeah, absolutely. It's like, dealing with a pretty complex legal system at a time when you're probably already dealing with a lot emotionally. So the aim here is to just clarify the crucial roles involved and the distinctions between the different types of, well, these personal representatives. We're going to stick closely to the information you sent over and try to make it as clear as we can.
So, okay, let's unpack this. Personal representative, that seems like the key term, like the big umbrella. It covers both executors and administrators, right? They're the people who are in charge of handling what the deceased owned.
Exactly. You can think of them as the people who are legally authorized to deal with everything, all the assets. And how they get that authority, that differs. So if there's a will, usually it names the executors. But what if there's no will? Or the people named as executors can't, or just don't want to do it. That's where administrators come in. But in both cases, they need formal authorization from the high court, a grant of representation to officially act. For executors, that's specifically called a grant of probate.
Got it. So let's start with executors then. Those are the folks specifically chosen in the will. What are the big responsibilities they shoulder?
The sources point to three main things. One, they gather and manage all the assets the person owned. This could be anything, right? Bank accounts, property, investments, even personal belongings. Two, they make sure all the debts and taxes owed by the estate are paid off. And three, their job is to then distribute what's left to the beneficiaries named in the will, making sure they follow the instructions in the document.
A lot to handle. And how many executors can there be? Can it be a whole team effort?
Well, there are rules. You got to have at least one executor, and the maximum is 4 acting at any one time. Interesting thing is, a will might name more than 4 people as potential executors. In those cases, the ones who don't step up immediately, they can have what's called power reserved to them. So they can step in later if needed, say, if one of the initial executors can't continue, like a reserve team.
Right, a backup squad. And you mentioned the grant of probate. How does an executor actually go about getting that, like the official confirmation?
So the grant of probate is that formal order from the high court, the legal recognition that the executor has the right to act. To get it, they usually have to fill out a form. It's called PA1P. Part of this process is about proving to the court that the will is valid and that they are the right people to carry out its instructions.
So you're named, you fill out the paperwork, court gives you the green light. But what if someone who's named as an executor realizes, wait, I actually can't do this? The sources mentioned renunciation and reservation of power. Let's start with renunciation. What's that all about?
Renunciation is when someone appointed as executor, they formally decline the role. The key thing here, and the sources stress this, is it has to happen before they start dealing with any estate stuff. It must be unequivocal, they say, like a clear, unambiguous decision.
So no starting to sort through things and then changing your mind?
Nope. Once you start acting as executor, generally too late to renounce, and if you do renounce correctly, you permanently give up all the rights and responsibilities that come with being an executor. And that means, of course, you got to have alternative arrangements for managing the estate. Usually, the process involves a formal written statement, signed, and all that.
Can you give an example of why someone might choose to renounce?
Sure. Imagine someone is named executor, but then they realize they have a conflict of interest, like maybe they owe the deceased person a lot of money. Renouncing might be the most ethical thing to do, or someone might just feel they don't have the time, the know-how, or frankly, the emotional bandwidth to deal with it all. In those cases, renouncing before you start is the right move.
Makes sense. Now, what about reservation of power? How's that different?
Think of reservation of power like hitting pause temporarily. The executor who reserves their power, they aren't actively involved in the initial stages, but they keep the right to jump in and get fully involved later on if needed.
So, not a permanent goodbye, unlike renunciation.
Exactly. Sources say this is often useful when an executor is, temporarily out of the picture. Maybe they're seriously ill or living abroad and can't deal with things right away. By reserving power, they let the other co-executors, if there are any, get started, knowing they can join in later if their situation changes. It's like holding their position, not giving it up.
Okay, let's use an example. The source mentions Mary, who named her kids, John and Alice, as executors in her will. John's overseas, can't handle things immediately, but maybe later. What are his options with this whole renunciation and reservation thing?
Perfect example. John's got two choices. He could renounce entirely, meaning he steps away permanently from anything to do with Mary's estate. Alice would then handle the administration solo, or he could reserve his power. That lets Alice get started, and John can jump in later if he's able, and things change.
So renounce, he's out, Alice does it all. Reserve power, Alice starts, John might join later. What are the implications of each choice, both for John and for how Mary's estate is managed?
Well, if John renounces, things might move faster at the beginning because Alice can just act without needing to check in with him. But it's permanent for John. He can't change his mind. If he reserves power, that gives him flexibility. He can see how things go and step in if Alice needs a hand or if something unexpected pops up. For the estate, it might mean a slight delay, potentially, if John does get involved later. But it also means there's a backup, more support.
Now let's switch gears. What if there's no will, or there is one, but the executors can't or won't step up? That's when administrators come.
Yeah, precisely. They're appointed in those cases. And there's a specific order set by law for who's entitled to be the administrator. Rule 22 of the Non-Contentious Probate Rules, 1987, if you want to look it up. It's a prioritized list based on relationship to the deceased.
Okay, let's walk through that list. Who gets first dibs?
Right at the top is the spouse or civil partner. If there's none, or if they can't or won't act, then it's the children. Or if a child died before the deceased, then their kids. After that, it goes to the deceased's parents, then brothers and sisters sharing both parents, that's whole blood, or their kids, then half-blood brothers and sisters sharing one parent or their kids. It keeps going. Grandparents, then uncles and aunts of the whole blood or their kids, then the half-blood ones or their kids. And finally, if no one else fits, the Treasury solicitor can step in if they're claiming, well, it's called bona vacantia, basically, stuff with no clear owner that goes back to the Crown.
A whole hierarchy. Any rules on the number of administrators?
Yeah, kind of like executors. Minimum 1, maximum 4. But there's a specific requirement for 2 admins in certain situations. If there's property left to a minor, or if there's a life interest in the property, meaning someone gets income from it but not the actual capital.
Yeah.
Extra protection for those beneficiaries.
And the official authorization for administrators, is it also called a grant of probate?
Not exactly. No will means a grant of letters of administration. They usually fill out form PA1A for that one. If there's a valid will, but no executors available, then it's a grant of letters of administration with will annexed. And funny enough, they use the same form as executors in this case, the PA1P. So the form itself doesn't always tell you who you're dealing with.
The source mentions clearing off, too. What's that about?
Clearing off is when you're applying to be an administrator and you're not the spouse or civil partner. Because of that strict order we talked about, you have to show the court why those higher up on the list aren't applying for the grant. You got to clear them, basically.
So explain why the folks ahead of you on the list don't exist or don't want the role or legally can't take it.
Exactly. The source uses Sophie as an example. She dies without a will, unmarried, no kids. Parents are alive. They're third in the order. When they apply to be administrators, they'll state in the application that Sophie dies intestate, unmarried, without issue. That clears off the spouse and children categories.
Okay, so we've covered how they're appointed initially, but what if, during the process, a personal representative dies? Does everything just, stop?
Not always. The source says if there are multiple personal reps, say 2 or more executors, and one dies, the remaining ones can usually keep going. Their authority isn't affected by the death of the co-rep.
What about if there's only one and they die before the estate is fully sorted?
If a sole rep who's already gotten the grant, probate, or letters of admin dies before finishing up, the court might appoint someone else to wrap things up, especially if there are minors involved. But if they die before getting the grant, well, their right to that grant basically ends. It's like they were never appointed, and then you go back to the administrator rules.
Now, this chain of representation thing, that sounds intense. What's that all about?
It's a specific legal concept for executors who've already gotten the grant of probate. If they die before they're done, and they've named their own executor in their will, that new executor can step in to administer the original estate. It's like the authority gets passed down a line.
So if person A names person B as executor, B gets the grant, then dies, but B's will names person C, then C can take over A's estate.
Exactly. The source gives an example. Dan appoints Mia. Mia gets probate, but dies before she's done with Dan's estate. Her will names Fred. Fred can now step in for Dan's estate, but And this is important. He'd have to agree to handle Mia's estate too in order to administer Dan's.
Hmm.
And this chain thing only applies to executors. If the reps of the deceased executor are administrators because there was no will, then this chain doesn't work.
And if a sole rep with the grant dies before finishing, and this chain isn't in play,
Then you need a special grant, grant de bonis non administratus, which means concerning the goods not administered. It's for the remaining part of the estate, and it's given to whoever would have been entitled if the original personal rep never acted.
so lots of detail on who can act and how they get the authority. But what powers do they have once they're in place? What lets them manage the estate properly?
They have quite a few powers, all designed to let them handle things right. The source outlines a bunch. For instance, they can invest trust funds from the estate. Under Section 3 of the Trustee Act 2000, they can generally invest as if they own the assets. But there are exceptions, like they usually can't invest in land unless they're specifically authorized to. They also need to make sure the investments are suitable and diversified to manage risk.
What about physical property, like land, a house, that kind of thing?
They can buy land in the UK. Section 8 of the Trustee Act 2000 covers that. Could be for investment, for a beneficiary to live in, or other estate-related reasons. When it comes to selling, they can definitely sell land if it's held by the estate as trustees. There's a bit of a legal gray area about whether they can automatically sell personal property, furniture, jewelry, that kind of stuff. To be safe, it's best to have an express power to sell personal property written right into the will.
And taking care of the beneficiaries financially, especially if they're kids.
They can use the income generated by the estate to help with maintenance, education, basically the benefit of beneficiaries under 18. Section 31 of the Trustee Act, 1925. Before 18, the personal reps have some wiggle room on how to use that income. Once they turn 18, if they have a right to the income but not the capital, they get that income, including any that was accumulated earlier. If their interest in the capital depends on something happening in the future, like reaching a certain age. Once they're 18, the trustees have to pay them the income, no more discretion to accumulate it.
And can they give a beneficiary their inheritance early if they need it?
Yeah, they can advance capital, give it to them sooner than they'd normally get it under the will or intestacy rules. This power, it's in Section 32 of the Trustee Act 1925, can only be used for their advancement or benefit, like helping them buy a first house or pay for important education. Used to be a limit. Before October 2014, for trusts created before then, only half of their share could be advanced. For trusts after that date, no limit. Importantly, if someone's entitled only to the income, like a life tenant, you can't advance capital to someone else that messes with their income without their written consent.
So are the personal reps completely in control once they're appointed? Or can beneficiaries have a say?
Actually, if the beneficiaries are adults, can make their own decisions, and are together entitled to the whole shebang, they can tell the trustees, which includes the personal reps acting as trustees, to step down and appoint someone new. That right comes from Section 19 of the Trusts of Land and Appointment of Trustees Act, 1996.
What if a beneficiary wants specific items, like family heirlooms, instead of just their cash value?
If a will leaves a sum of money, a pecuniary legacy, the personal reps can let that beneficiary take specific stuff, furniture, jewelry, up to that value, as long as those items haven't been specifically left to someone else in the will. The beneficiary has to agree to this, though the will can say they don't need to. That's Section 41 of the Administration of Estates Act, 1925.
Can they get insurance to protect the assets?
Absolutely. They can insure any trust property, including the estate stuff, against loss or damage, and they can pay the premiums from the estate funds, either capital or income. Section 19 of the Trustee Act, 1925, gives them that power.
Last one. What about money for kids? Can a kid legally sign for a big inheritance?
Generally, a minor, someone under 18, can't give a valid receipt for big assets or income from an estate. The Children Act, 1989, does allow parents with parental responsibility to handle money on their kids' behalf for their benefit. But that's not always practical, especially with tricky family situations. So usually, gifts for minors are either left to trustees who hold and manage them until they're adults, or the will includes a clause saying the reps can accept a receipt from a kid over a certain age, often 16.
Wow, a ton of info. To sum it up, what are the big takeaways for our listeners?
Totally. First, executors are named in a valid will, and that will needs to follow legal rules in writing, signed by the person making it, the testator, witnessed by two adults, Section 9 of the Wills Act, 1837. They also have to have testamentary capacity, meaning they understand they're making a will, know what assets they have and who their beneficiaries are and what their claims are. Banks v. Goodfellow set the legal test for this, which also looks at if they have any delusions that affect their decisions. We also talked about renouncing, permanently refusing to be executor before doing anything, versus reservation of power, stepping aside temporarily, but keeping the option to join in later.
The sources had some multiple choice questions too. Let's touch on those quickly. First one, Jonathan Hargreaves, some executor changes. Who is the right person to apply for the grant?
Even with the divorce and the initial executor passing away, it was Edward Thornbury. Couple of key points there. Divorce usually revokes any appointment of the ex-spouse's executor, and an executor's role doesn't automatically go to their personal rep. So even though Lucas was executor for Michael, he didn't inherit Michael's role as Jonathan's executor.
Second one, Emily Smith had to step back temporarily because of her pregnancy. What was the key principle there?
Classic reservation of power.
Yeah.
She was taking a break but keeping the legal right to be fully involved later. Very different from renouncing, which would be permanent.
Last one, Sarah Jennings, thinking of stepping down but maybe wanting to come back later. What did that show us?
That one highlighted the difference between renouncing and reserving power. Sarah had to decide, permanently renounce, which she'd need to do before doing any executor stuff, or temporarily reserve her power, again, before getting involved. Renouncing, that's final. Reserving, that gives her that flexibility to participate later.
So listeners, we've really gone deep on executors and administrators, the folks who handle things after someone passes away, how they're appointed, the importance of a valid will for executors, the priority order for administrators when there's no will, the difference between renouncing and reserving your power to act, and some of the legal powers they have to manage the estate and distribute the assets.
It's really useful to get this stuff, whether you're the one being appointed or your beneficiary. Makes what can be a tough emotional process a bit easier to understand.
And here's something to ponder. What factors do you think might make someone appointed executor decide to renounce entirely or just reserve their power? And how could those choices affect how smoothly the estate is administered? Any unexpected wrinkles that might pop up depending on what they choose? Definitely something to think about. Thanks for joining us on this deep dive.